Speaking of tort reform,
Yes.
why don't we touch on that for a second in Texas tort reform?
Okay.
Reform.
Yes.
But when you said that, my ears immediately perked up because this is something I've harped on for years in regards to exactly how that reform here in Texas truly does harm patients.
Yes.
Do you want to speak to that a little bit from your perspective?
How long have you got?
Till our next topic.
And do you have a Kleenex? AdvoKAYte, holding healthcare accountable. This podcast is my way of sharing what I've learned about the mistakes, the cover-ups, and the ways we can all protect ourselves. We're all in this together. I'll sum it up this way, and I really do want to do a deep dive on this. Mm-hmm. I want to do at least one episode on it, if not 2 episodes on it. But it goes something like this. Mm-hmm. Patient safety should not be political.
Absolutely.
It is wildly political, wildly so. So tort reform, I'm like, no, what exactly needed to be reformed to begin with? Mm-hmm. But there was a public relations political campaign to convince voters that we had a lawsuit crisis in Texas, that plaintiffs' lawyers like myself were filing frivolous lawsuits, and that they would take these cases to trial, and ordinary citizens who would be selected for jury duty would suddenly lose their minds and go off the reservation and give these ridiculous awards. Because of that, doctors, their malpractice rates rose. Doctors couldn't afford the malpractice anymore to be covered, and therefore all of our good doctors were going to leave the state, and we were just going to be left with crappy doctors. Well, a couple of things about that. There never was a crisis. I've been a medical malpractice lawyer for, I don't even know, 35 years or so. It's hara-kiri, inflicting self-harm on yourself to file a frivolous lawsuit. Mm-hmm. Why? Because you will normally spend 3 to 5 years of your professional life working, hoping against all odds that you can win the case so you can be paid for your time and get recovery for your client. Mm-hmm. You will often spend $100,000, $150,000, $250,000 out of your own pocket on a single case to do it. So why would anybody file a stupid lawsuit unless they didn't know what they were doing? Mm-hmm. As well, jurors come in all shapes and stripes, but it is very, very, very rare for a jury to lose their minds and give a runaway jury verdict. When they do, it is always appealed. And in Texas, I haven't kept up with it lately, but at one point we had something like a 83% reversal rate of favorable jury verdicts in the state of Texas. So, it's just another example of focusing on the wrong thing. So rather than fixing the system that is hurting patients, why don't we just take their rights away? So when they are hurt, they can't seek recovery for it. Right. Some may say, okay, they can still seek recovery. There's caps on the amount that they can recover. The answer is sort of true, sort of not true, because the caps are so severe in some cases that a lawyer cannot take the case. Right. Because you can't spend 3 to 5 years on one case, and it has only this amount of damages that can be recovered to pay for attorney's fees and expenses. The expenses will be more than the outcome could ever be. So it really, what it did, bottom line, is it closed the courthouse doors for the vast majority of patients in Texas who are the victim of a preventable medical error.
Absolutely. And I know I know we definitely need an episode on this.
Yes.
Because I know it's not just Texas. I know Florida has very similar laws. And, I've just heard so many, heartbreaking cases where, patients are absolutely harmed by this tort reform, as they call it here in Texas, because there's so much that's protecting, the healthcare systems, the doctors themselves, and so forth. And that leaves the patients, to fend for themselves, essentially. Like you said, they could have significant issues. They could have misdiagnosis. They can have, a lot of different things happen. And a malpractice attorney can't take their case because financially it's not feasible. So,
Right.
Okay, I will let that go for now. But I know we will circle back because that one, we're both very passionate about how that's impacted patients here in Texas. So.
For sure. And we definitely will come back to that. But I will say it's kind of the double whammy on innocent people because their trust in the medical system was destroyed. And then when lawyers like me say no, then they lose faith in the legal system. Yeah. And some people attribute poor motives to us. Yeah. And, I'm like, don't kill the messenger. We try to help as many people as we possibly can. But it's across the board. It's First of all, there's not very many medical malpractice lawyers that stayed in the profession after tort reform because, they had kids to send to college. They had to go move on to something more lucrative, easier. But of the small group of really competent medical malpractice trial lawyers, I would say on average, they will keep about 1%. They will be able to accept about 1% of all cases that come to them.
It's just sad. Yeah.
So it's pretty bad odds. So we try to educate people about that, but they still get mad at us, and I wish they wouldn't because it hurts my feelings.
Well, I remember calling you one time and I said, what do you mean you can't take this case? It's awful. And then you had to educate me as to why. And so, that was very eye-opening. So,
well, I just wanted to reassure you that lawyers do have feelings.
Oh, I know.
And, it does hurt my feelings when we really do try to help. That's why we went to law school.
Right.
To help people.
Absolutely.
But, people are hurting, they're suffering, they're got medical bills piling up, and then it's just one more person that let them down. So we get it.
Right. Speaking of why, you went to law school, I think we were going to talk about those early years and what you were doing back in that time frame.
Oh, my Lord. Well, how much time do we have to get into that? And this is a PG-rated show, too. Are we going to talk about our 20s or?
Well, you had asked me what I was doing in 1985 when you were starting this out, and I had to laugh because I was wearing leg warmers, playing with Cabbage Patch dolls, and watching Saturday morning cartoons.
Oh, my gosh. So how old would you have been in 1985?
9.
9 years old.
I would have been 9 years old. Yeah.
So in 1985, I was about a 26 or 27-year-old young woman. I was an assistant district attorney in my hometown of Comanche County, Oklahoma, and I was a misdemeanor prosecutor. I was thrilled to death. I was making $25,000 a year. And I went out and bought a used 280Z, which most people listening to this, well, only the old people will know, but that was a hot sports car. And, of course, it being the 80s, I had big permed hair and, the whole thing, flowery dresses. We dressed up every single day for work. Pantyhose, high heels. Either a dress or a business suit, which back then women wore like men's suits except with a skirt. So we'd wear the skirt, the blazer, and usually like a cotton type shirt, an Oxford cloth shirt, and then we had like these string ties or whatever. That was the uniform. So, I remember when I got my job, I went to, there was a place, it was a local store in Norman, where I went to college, University of Oklahoma, Boomer Sooner, and they would extend a small line of credit to you. So I bought a navy suit and a camel hair suit, and I was ready to roll. And immediately went into the courtroom. Should I have been turned loose? Probably not. But it was really, really a cool time for me because I did go back home, and my parents were both still living. The district attorney's office was on the 5th floor of the courthouse, and the court clerk's office was on the 1st floor. And my aunt worked on the 1st floor. So it would not be uncommon at all for me to be in court trying cases or whatever, and to turn around and mom or dad or my Aunt Louise would be in the back of the courtroom. So it was an idyllic time for me.
A 280Z, I have to admit, I really don't know what that is. But I will say, when we started talking about this time frame was because in 1986 is when the Healthcare Quality Improvement Act was passed by Congress, which governs the National Practitioner Data Bank. And they wrote a guidebook 4 years later. And when you were in your 20s, I was only 9 years old. I think I was 10 years old, actually, when it was passed by Congress. And it hasn't really been updated since. So here we are, almost 40 years later, the same laws in place. We've talked about the need for reform. We talked about the need for improvements and the loopholes and why it needs to be updated. And, how, hospitals and systems and ambulatory surgery centers and everything, they take advantage of those loopholes, at least the bad ones. The great ones really do like the right thing. And, for me, as I said, it being a consultant, one of the things that I do when I come into a healthcare system and we start talking about reporting to the data bank, and when you're looking at a patient safety issue, a quality issue, I always tell the physician leaders and I empower them and educate them. It is your responsibility to uphold the patient safety standards. Let's put reporting off the table. Let's really look at a case and break down what is best for patients. And let's start there. Forget reporting and whether or not, you have to report this doctor, but let's focus on that. And then we'll talk about whether the action that you took, which is the appropriate action, whether it's reportable. But with the data bank, when that was put into place, it does require that hospitals report any type of significant action. If they take action against a physician's privileges, if they were restricted and so forth, they're required to report that to the data bank. So you and I have done a lot of advocacy around this. And, even recently we were helping to hopefully promote some changes to legislation there. And so tell me about, your thoughts on that process. I know that, but let's talk about that a little bit more.
Well, I still want to keep talking about my 280Z.
You're going to educate me on what that is. It sounds like a cute little sports car. I'm going to have to Google it.
Cute little sports car. It was, all the rage back then. But you made me start thinking about that, which is the 280Z had 8-track player.
I do know what an 8-track is. I do know what that is.
Yes. These huge, we'd carry these huge things around, and it was pretty cool. We could play music. No airbags. No cell phones were not invented.
Right.
When they were invented, you could have it hardwired into your car and have a, that came later when I got my Acura Legend. And I was the coolest kid on the block because I had my little bat phone hardwired into my Acura Legend. But, think of where we are. Think of where the automobile industry has progressed since 1985 and 1986. Autonomous driving vehicles.
Yes.
Now, my car is smarter than I am now. So most people would be shocked at how little this aspect of healthcare has evolved. And it's not for a lack of trying. I'm always reminded of our dear friend, whom we love, Dr. Bob Oshel. And Bob will tell a story, and we'll have to have him back to tell the story about how it's been now 25 years ago or something. Yeah. They got all the stakeholders in one room. They had like a, at a Marriott in Orlando or whatever, the head of CMS is there, the American Hospital Association, the American Medical Association, the Joint Commission, CMS, Office of Inspector General, I think, whatever, to say, folks, the data bank isn't working.
Yeah.
This genius idea that came about in 1986 isn't working, and it's hurting patients. Can we agree on what needs to be fixed? And lo and behold, they agreed. I also should say public citizen was there. They all agreed, and they came out with a consensus statement. And yet, not a single one of those consensus recommendations has ever been implemented. And I just, for the life of me, I can't figure out why.
I can't either. And this is what we talk to Bob about all the time is it's so challenging and so difficult to make changes because it has to go through Congress in order to modify that law. And the data bank guidebook is dictated by that law. So when you have these big organizations that govern everything in healthcare come together and agree that something needs to change, and here we are 25 years later, and we're still struggling with the same issues, it's extremely frustrating. Yeah. And so, as we've talked about with some of these loopholes, that, Bob has worked endlessly, to try to change and, educate the public on. It starts with educating, healthcare systems, their attorneys, as a consultant. I think one of my biggest frustrations as a consultant is when I walk into a hospital and we start talking about peer review. And I ask, okay, well, did you report this to the data bank? And I met with, a blank stare, or, oh, no, we didn't want to report because we don't want to ruin a physician's career. And then I have to take a step back and say, well, let's do some education here, right? And so some of the hospitals, I've come across in my career as a consultant would do these, they take advantages of those loopholes out of whether it's fear of retaliation, fear of being sued themselves, lack of education. I mean, there's many reasons why hospitals have not reported when they should have. Some of it, for example, if you put into place a mandatory proctor, meaning a physician has to have somebody else with them in the room, either before, they can deliver care, they have to approve the plan of care, or they have to directly observe the care that's being provided. That's a limitation or restriction of privileges. And a lot of organizations don't realize that's reportable if it goes beyond, 30 days. And speaking of 30 days, a lot of hospitals will go do the loop where it's like, well, we'll suspend for 29 days so that we don't have to report. And so that's going back to my first comment where my, priority when I first walk into an organization and I see these types of things happening is to have them back up, and I empower the physicians. And I said, and I remind them that through the AMA and the ethical, responsibilities there is their duty to report, whenever they see physicians that are not upholding, best practices or patient safety and that are doing harm to patients. That is their ethical obligation. And so when you start with empowering the physicians and you say, take reporting off the table, it doesn't end somebody's career, but you have an ethical obligation. And then you look at the administrators, of course, and say, you have a legal duty and responsibility to follow this. This is a federal law. You are mandated to report this. And you have state laws, of course, as well, where they report the state medical board. But once you do that level of empowerment and education, it does help to kind of open the door to say, okay, we are going to report. But yes, in my career, I've seen so many hospitals take advantage of those loopholes, or, they write negotiated agreements where they'll separate employment, or they'll negotiate that we are not going to report so long as you kind of just quietly go away, right. Which I think we saw, right, in the Dunch case. And so those are the things that we really want to prevent. We want to close those loopholes. And the way the data bank guidebook is written, it allows for that. And so that's why we've been saying this really needs to be tightened up. They really need to rewrite this guidebook. But then it's like they need individuals that have the experience and the know-how to do that work. Because if it's not, then we're going to continue to go in circles. So,
well, I totally agree. You have to rewrite the guidebook. Mm-hmm. You're going to rewrite the guidebook and close the loopholes. Mm-hmm. And there's still going to be lawyers, good lawyers. Some of them are our friends. Well, they've got their own job to do,
Right.
and they're going to keep advising the hospital like, well, look, they closed this loophole, but here's another loophole.
Yeah.
Like tax lawyers advising clients, here's how you can probably not pay taxes on this and not get caught or go to jail. And so we're still going to have that problem. I think we can shore up the protection for hospitals that do the right thing and not have fear of being sued by the doctor for doing the right thing. But I also think there has to be punishment for hospitals that break the law.
Well, speaking of the punishment, there is supposed to be a punishment that is written into that law that for those who fail to uphold their obligation, that they will be penalized. They may lose their ability to have the peer review protection. It's never been enforced.
Never.
There's fines. No one's ever been fined for not reporting. So that's another place where that law has failed.
I could walk you through all of the cars that I've had since 1986 because I'm a car fanatic and my dad was a small town car dealer. I could take you through the entire history of my cars since then, and yet not one single hospital has ever been punished for breaking the law by not reporting a dangerous physician. It's outrageous. But I'd like to say that I'm polyperfect and that I would always stop at the stoplight, no matter if I thought I was going to get pulled over or ticketed by the police or not, that I would always drive the speed limit, no matter whether I thought I was going to get pulled over, that I would always pay my taxes on time or at all. But if I was just allowed to run wild, and I knew nobody's ever going to do anything to me, so maybe I'll pay my taxes, maybe I won't pay my taxes. Well, when it comes to my clients, nothing will ever happen to me if I don't file their lawsuit on time and I let the statute of limitations run on their case. Well, maybe I feel like showing up to court this day, maybe I won't. Nothing will ever happen to me. And these are probably ridiculous examples, but truly, we have created this system where we're counting on industries, hospital industries, and people within those industries to self-regulate, and we just trust that they're going to do the right thing. Some will. We know at least 50, 60% at least won't and don't.
Right. And you get those statistics from Bob, who has all this statistical data from the NPDB, because he used to, of course, oversee that area of the data bank. It still has, information and access to those statistics. I think that, what you'll see in a really good system is their attorneys also, support this, because they'll say, make sure you document. Let's talk about this. Let's focus on, you are doing the right thing and we're here to help defend that decision. Let's document it. Let's make sure that you are being fair, because you also have to think about fairness to the practitioner. You have to make sure that their due process, they have due process, that they, are being treated fairly as well. But I agree. You have to be able to look at these things not in a silo, but as overall as a system. You have to have consistency. You don't want to have the potential for somebody to allege bias and so forth. But I am not, to clarify, I say this very often, I'm an attorney, but I'm not an attorney for a hospital. I work with the physician leaders, and I, really help work, through this with them and help educate and so forth. But when you have attorneys, general counsels in hospitals who are not educated on this, or who try to skirt that system as well, that's where you run into these loopholes, right? And it's not that they're bad people. I don't believe that. I believe that, they're, as you said, they have a job to do, and their job is to defend the hospital, protect the hospital from liability, from lawsuits and so forth. But, as they start working through this process and they become a part of that culture of patient safety and they see the benefits of a very thorough peer review process where you get ahead and you take immediate action, then they're there to defend that action because they know that you're doing the right thing.
Yep.
So
Exactly. Well, I think we should probably wrap up this episode, but this is why we spent the whole first season talking about Christopher Dutch.
Yeah.
It's because we really thought that as much media attention as that case got,
right.
that would be the impetus for people, politicians in particular, to go, okay, enough is enough. We get it now. Mm-hmm. But segue into the next episode.
Yeah.
We know the problem existed long before Christopher Dutch. We know the problem has continued to persist. So if you would be good enough to join us for the next episode, we're going to, go into some of the more extreme cases we've seen of really dangerous doctors.
Absolutely, because you're right. He was not the first. He won't be the last. And we know that we have a long list of those who just didn't get the same media attention. So, but you're right. You would have thought that this outraged everyone. Everybody who listened to this widely downloaded podcast and, were outraged. They're like, how could this happen? But we're still talking about it because there still needs to be system changes.
Yeah.
So.
And we still will be talking about it until it changes.
Absolutely.
Yeah. All right, Ann. Well, thank you so much.
Yeah. Thanks for having me again, Kay. Always lively conversation. I have to go look up the 280Z.
Oh, yeah, exactly. Maybe I'll post a picture of it in the show notes or something. But, well, thanks everyone for joining us for another episode of AdvoKAYte, Holding Healthcare Accountable. Please come back and join us next week for a continuation of my conversation with Ann Roberts, where we're going to go through some stories that are kind of unbelievable, but you won't want to miss it. Thank you again.